Y'all got your witness handy?
He's on his way in, Judge.
Welcome. Have a seat, ladies and gentlemen, in the courtroom. Welcome back, ladies and gentlemen. They say they've got it fixed, so we'll see.
Fingers crossed.
You may proceed, counsel.
Yes, Judge. Welcome back, Sergeant.
Good.
And prior to the break, we were discussing a number of videos that you had reviewed.
Yes, ma'am.
And while we have the technology working correctly, we're going to go through the videos sort of one after the other, and then we'll come back to our discussion. Is that all right?
Sure.
Thank you. So I'm tendering first, I'm publishing first what's already been tendered as State's Exhibit 6. Detective Sergeant Hogan, can you just tell the jury what we're looking at here in State 6?
Sure. At the bottom of the screen here, that is the hood of the Dodge, of the pickup truck. So the camera, you can imagine, is almost attached to the dash, in the center of the dash, above where the radio and stuff would be. And it's recording everything out in front of the truck. The truck is backed into the parking space. Behind the truck is along the back of the Longhorn Steakhouse. This is a little access road that runs from, I think it's Lindbergh, up to and connects the road that goes to Tongue and Groove. Piedmont Avenue is directly behind and in front of Longhorn Steakhouse. This is the entrance to the parking deck that I was talking about earlier. Video cameras were stationed there close in that opening before the cars coming and going. This is the Kia to the tinted windows. Other cars are not relevant.
Playing now State's Exhibit 6 in its entirety, and for the record, that video is 3 minutes long. Sergeant, at the beginning portion of the video, we had a loud crash. What's going on in State's Exhibit 6 at that time?
That's when he's breaking the back window out of the rear passenger door. Also, too, what I'd like to point out, when he exits and enters the truck, and while he's in there, you can see the frame's kind of shaking of the truck. That's because the camera's attached to the dash, so when the truck moves, the camera moves. One thing that I noticed was that when King exits the car, when anybody's in the car, that car would be moving too. The Kia does move when he exits and enters the Kia, when King does, but it doesn't move anymore when he's out of the car.
And what are the sort of the traffic conditions at the time when he backs up and stops?
Oh, it's sparse traffic conditions. It's really just people coming and going for the parking deck and the valet service driving customers' cars back and forth. But again, this is very early in the morning. That's after midnight. 1:30 in the morning. That's not a whole lot of traffic.
And at some point we noticed towards the end that Mr. King returns to his car. What else was going on at the time when he returns to the car?
He continues to with his burglary, looking for stuff.
And when he returns to his own Kia, were there any other vehicles coming at the time?
Yeah, the two cars, that's what I described earlier, where he was in there and he got spooked for whatever reason. He jumped out. I guess my theory is he saw these cars coming and he got a little scared that they might notice him. So he got out of the car and got ready to leave. And when he decided that they weren't interested in it, he got back in the truck.
Thank you. We will now move on to Exhibit 7. Similarly stated, Exhibit 7 is approximately 3 minutes long.
This is the same camera, just the angle is pointed back into the truck.
Now, from the back of the truck, are we seeing anyone sort of walking past the truck?
I don't believe in this clip, no ma'am. At one point, Mr. King did walk around the truck, but I'm not sure it's in this clip.
Okay.
Now, you can see the alleyway that goes up to Piedmont, and that's where the majority of the traffic was out at that time in the morning. Back behind the Longhorns on that little access road, there was traffic was sparse. See the tool that he used to break the windows in his left hand.
Do you notice anything else on his hands?
Gloves.
Thank you. And when he exits the first time, that when he goes back to the car when the white SUV was coming around that corner,
That's correct.
does he return to the truck?
He does.
What is different the second time when he comes back as far as what he has in his hands?
Well, he's got a light, which turns out to be a cell phone, but it's a light, so he can see better.
Okay. Moving on now to the first 40 seconds, sorry, of State's Exhibit 10. Before playing in its entirety to 40 seconds, what angle are we looking at now?
Again, this is the same angle as the previous. It's looking back into the truck.
What just happened then, Sergeant?
This is when Mr. Harrison, Olvie, pulled up and noticed him, and they saw each other.
And what did Mr. King do?
He, well, he jumped out of the truck.
And now playing 6 Exhibit 9 in its entirety, and for the record, that video is 3 minutes long. What angle are we looking at in States 9?
This was the first angle we looked at. It's the angle looking from the dash out the front of the truck. Mr. King has re-entered the truck, and he's left the driver door open to the Kia. The interior light to the Kia is not illuminated, indicating that he turned off that mechanism where it wouldn't illuminate.
What just happened?
Mr. King just shot Mr. Olvie.
What did Mr. King do next?
He drove away.
We discussed earlier in the first half of your testimony that you located some videos at the Fairmont location.
Yes, ma'am.
And publishing was already in evidence at States 114. Sergeant, what are we looking at in States 114?
This is the entrance exit for the parking deck at the Fairmont address.
What do we see in that camera angle, camera 29?
That was the Kia that was being driven by Mr. King.
Can you tell what the rate of speed, whether it was coming fast or slowly into the complex?
It appears to me he was not being very safe coming in there. I mean, he was going pretty fast.
Moving on to States 115. That we just look at a different angle of the same entry.
That's correct, yes, ma'am.
Okay, now it states 116. What are we looking at now?
This is the interior of the parking deck he just entered, and he's just going around the circles, going to his parking spot.
Now at 117.
That's the same parking deck where they have commercial property. The lower portion of the parking deck is for the commercial use, and then the residents to the apartment have access to get into the secured area above. So that's where he's going in.
Moving on to States 118.
Another angle. Same scene.
We're still in the interior of the deck.
Yes, ma'am.
Now, states 119.
And that is Mr. King parking back in the parking spot.
And just to be clear, this is all in the early hours of the morning on September 3rd of 2015.
Yes, ma'am.
Moving now to states 120. What do we see now in states 120?
This is Mr. King after he's exited the vehicle, walking up, using a little key fob thing to open the door.
And is the shoes on his feet and the clothes that he's wearing consistent with the clothing and shoes he wore in the video at the
Yes.
Longhorn Steakhouse location?
Yes, ma'am.
Were you able to speak to Ms. Sweeney directly at any time?
No, ma'am.
What was that?
Wasn't able to get in touch with her.
Okay. Now, Detective, in the moments after sort of the violent crime, is it sort of fairly normal for information to be incomplete or perhaps conflicting when you first report on the scene?
Sure, yeah, it happens quite often. From anybody that's a witness, everybody sees things differently. It's a chaotic situation, a lot of moving parts. Your adrenaline, you get adrenaline not whether you're a witness to it or you're involved in it, especially if you're involved in it. You get a lot of big dump and things. People get tunnel vision. They hear things. Sometimes they hear things that weren't there. Sometimes they don't hear things that were there. It's all. Sometimes they're really scattered. There are common denominators, but you have to understand that everybody does see things different. So when we do get information, we try to verify it because of that fact.
Now, early on in the investigation, did you ever become aware that there may have been some talk, conversation, suggesting more than one person might be involved in this investigation?
I've never heard that until recently yet.
Okay. And did any of the information you developed during the course of your investigation point to a possible second actor in this case?
No.
Were you provided any names, descriptions, or any identities of a possible second actor in this case?
No.
As the investigation sort of progressed, what specific bits of evidence became relevant to your investigation?
Well, obviously the car, the shell casing, the video.
Why was the shell casing significant?
Because we didn't find a shell casing on scene. That was a bit of a mystery. So we saw the video and saw that the gun had been fired from inside the car. So when we found the shell casing inside the car, it was obviously a big bit of evidence that furthered the proof for the evidence that I need for the probable cause for the warrant.
And specifically, where in the car was the shell casing?
The driver's side floorboard.
Was it sort of just in the open, or where was it specifically?
It was, you can see in the pictures, it was laying close to the driver's seat. There was a medical, like a COVID mask on the floor right next to a COVID mask.
And did you recover a handgun inside of that car at all?
No, ma'am.
Why were you not able to test the shell casing to a handgun?
Say it again?
I'll rephrase that. Were you able to do any ballistics in this case?
No, ma'am.
Why was
Well, really, the only thing we could use was, obviously the shell casing was a spent shell casing. When the bullet's attached, it's a bullet. When it's been fired, it's a shell casing. The casing houses the gunpowder, the primer, and the bullet for the gun. So when the gun fires, the firing pin hits, ignites the gunpowder, it shoots the lead bullet out, and then ejects the shell casing when you have a semi-automatic. Of course, a lot of people think you can get DNA or fingerprints from the shell casing because somebody had to load that into the magazine to shoot through the gun. Well, if we get bullets that have not been fired, that's the case. We can sometimes get DNA and fingerprints from, but when the gunpowder ignites, it makes it very hot and it burns off any kind of evidence that we could get. It burns it off and it makes it useless. And we can match that shell casing to a particular handgun if we had it. In this case, we don't.
Now, while we're on the subject of shell casings, are you familiar with gunshot residue and gunshot residue testing?
Yes.
How are you familiar with that?
I've used it on several occasions during the course of my investigating homicides.
Well, typically, what is the time frame required to do sort of gunshot residue testing?
It's typically hours. The gunshot residue test, you can use it for clothing and for skin, and it's a cotton swab that you swab, and then you have it tested for gunpowder residue. But gunpowder residue doesn't last forever. If you wash your hands, you could, if you sweat a lot, if you get them wet, if you're wearing gloves, you're not going to have the residue on you.
And was any gunshot residue testing done in this case?
No, ma'am.
We were just on the subject of the shell casing, and I'm publishing my writing evidence on stage 77 with one yellow placard in
Yes.
that photo.
Yes, ma'am.
Can you describe to the juror what we're looking at?
Sure, this is when we did the search warrant on the Kia, we looked in there and we obviously saw this. The placard is to mark just the evidence number, and these are inches across the bottom, so you kind of get an idea of scale. Obviously, as I described earlier, there's like a COVID medical mask laying there, and right beside it is the shell casing.
Now, are you familiar with ejection patterns of handguns?
Yes.
Typically, how do 9mm eject? How does that work?
They eject up and to the right. So if you're shooting the gun, it's going to go up and to the right, every time you shoot on the semi-automatic handgun.
And placard number 1 would be in relation to the sort of the wheel of the Kia. Is that to the left or to the right?
It's to the right.
Thank you. And we just sort of zoomed out a little bit on the photo of number 1, just to sort of orient the jury as far as the spacing. And can you describe sort of how it is in relation to the driver's seat?
Well, as you can see, you can't see the shell casing from here, but you can remember where it was. You can see the medical mask. So it is up and to the right, or excuse me, it's forward and to the right of the driver's seat. Kind of laid against the console wall.
Thank you. Now, you testified just now that the gun was not recovered, or no gun was recovered in that car.
No, ma'am. It's rare that we do that.
Correct. But is the location of the shell casing to the right consistent with a handgun being fired from the driver's seat?
Yeah. So when a handgun's fired in a closed space like that, it's going to go up the right. It's going to bounce around. But it's in the general area what I would expect the shell casing to be. They'd have been fired from the driver's side. Yes.
just, Detective, just to kind of round things off, you also collect additional physical evidence in this case?
Yes.
I'm handing you the markers.
These are, Harrison's clothes.
And what was the clothes you recovered on the person of Mr. Olvey on September 3rd of 2023?
Yes.
And this exhibit attendant to the record states 1, 2, 3.
Admitted.
And so, Sergeant, once you reviewed the videos, spoke to the witnesses, reviewed physical evidence in this case, and you took out warrants, was that the end of your investigation?
I spoke with the mother, I think, after the warrants were issued. And I assisted with the fugitive detectives in apprehension as best I could, and then also with Marta.
And all of the events we just discussed, did that happen here in Fulton County?
Yes, ma'am.
Thank you. Nothing further from the state.
Is it detective?
Well, it was. It's sergeant now, yes, sir.
Okay, Sergeant. Sergeant, when you agreed with me that on the video, the Kia windows were so tinted you could not see who was inside the vehicle, correct?
That's correct.
And in fact, one of the witnesses testified actually earlier yesterday, and I think that he was a parking attendant at the neighboring business, indicated that he saw it speed off, but he could not see who was inside the vehicle. Do you remember a witness telling you that?
Both witnesses I spoke with said they did not. They
Okay.
saw the vehicle, but didn't describe anybody inside, yes.
Okay, all right. And also, with that being said, you testified that you saw Mr. King shoot the victim on the video.
I did, yes.
Okay. Was it a different video than what we just saw?
No,
Okay. All right. So did you see a gun in the hand of Mr. King?
I did not.
Did you see Mr. King actually shoot the victim on that video?
I saw Mr. Over get shot, and I know a ghost didn't shoot.
Okay. So you saw somebody inside that vehicle shoot the victim, correct?
So, yes.
But you didn't see exactly who, correct?
Can't see exactly who.
Okay. And were you aware that the victim indicated that there were two black dudes?
Yes.
Okay, all right. So with hearing the victim who was there indicate there were two black dudes, you did not feel it was necessary to explore that?
I didn't discover that until later on,
Okay.
but just recently, really.
Okay, and in fact, the vehicle that Mr. King was in was not even his vehicle, correct?
That's correct.
It was not registered to him, correct?
That's correct.
And the fact that he's driving another person's vehicle, that was not enough for you to try to see if there was someone else involved?
I looked at the video, I fouled many times, I don't know how many times. Slow motion, forward, backward, frame by frame. Everything that I know based on my experience of how people behave when they're involved in crime tells me that he was alone. There was nobody in that car.
Okay.
I can explain that further if you like.
No, No, if I want to, I ask you that. But let me ask you another question. If the victim was shot at close range, anybody inside that car, whether it be a passenger, back passenger, if they would have shot the victim, that still would have been close range, correct?
Sure, yeah.
Okay. All right.
If you want to get, close range, there's press contact, there's contact,
That's all
there's a few inches, there's a few feet. It's all close range.
Okay, thank you, sir. Did you interview the witnesses on that night?
Yes.
Okay, how many witnesses did you interview?
2?
And do you remember the names of the persons that you interviewed?
Yes, sir.
And who were
Spoke
they?
with Noah. Oh. Noah Harper and Kayla Gowdy.
And who?
Kayla Gowdy.
Is that the person that called 911?
I'm not sure if she
Okay.
did or not.
Okay. Is Kaylee a female or male?
Female.
Okay. Did you actually interview the manager, the valet manager?
If Noah Harper's the manager, then yes, I did. I don't know who's the manager or not.
Okay. No, he's not the manager. He's a parking attendee. So that means you did not interview the manager, the valet manager, correct?
That's correct.
All right. And you indicated that there was no gun recovered from Mr. King.
That's right.
During the course of your investigation, did you ever make a determination as to how many valet attendees was working that night?
Well, I know of 3. That's all I know of.
Okay. And as we look at the video, did you observe on video Mr. King climbing across the seats of the truck when he was inside?
Yes, sir.
Okay. And did you notice, obviously, he was kind of facing down, and he was kind of in the upside down position?
Certain times, yes, sir.
Okay. And we noticed his clothing he had on, correct?
Yes.
And you notice the amount of movement he did going in and out the window, going in and out the car, correct?
Yes.
And during that period on the video, despite all that movement, we did not see any weapons or guns on him during that period of time, correct?
No, sir.
Despite all the movement he made, there was nothing bulging out of his clothing or anything like that, correct?
I didn't notice any, no.
Okay. And out of the witnesses that you interviewed, none of the witnesses ever indicated to you that they saw my client, Mr. King, pull out a gun, have a gun, or brandish a weapon, correct?
That's correct.
And the shell casing that you recovered was inside the Kia, correct?
Yes, sir.
And there was no other shell casings outside or near the truck or near or on the ground in that area, correct?
No, sir.
And you don't have any physical evidence that actually tied Mr. King to the actual shooting. I know you have evidence that tie him into the breaking into the vehicle, but you don't have any physical evidence that tie him into the actual shooting of the victim, correct?
Yes, sir. I do. The video.
The video, you agree with me, the video is limited as to that particular incident of Mr. King actually shooting the victim. You don't have him on video with a gun shooting the victim, and you see his face, correct?
Within a split second after he enters the car, there's a gun produced, and he shoots.
Okay.
Mr. O.
Within the point that he enters a tinted window, car that has a dark tinted window where you cannot see who's inside, then the victim is shot, correct?
Yes, sir.
And it was some time before Mr. King was apprehended, right?
Yes, sir.
And it was some time before the vehicle was actually seized or searched, correct?
I think it was seized on the 4th. I think it was. It was searched on the 11th, I believe.
On the 11th, right?
Hold on one second. I'm going to double check that. Yes, on the 3rd that afternoon, or late in the evening on the 3rd, is when the car was discovered on the day of the incident. And
So
then-
obviously, the time had elapsed for if there was anyone inside that vehicle, they would have obviously exited the vehicle and went their own separate ways, correct? It was so much time from the point that the vehicle was seized or Mr. Randy King was seized, that if there was someone else in that vehicle, they would have been long gone. That's my point. He wasn't captured right then and there, correct?
Only one person was captured coming out of that car, from the parking deck.
But I don't think you understand what I'm saying. The vehicle was not stopped immediately after the incident, correct?
No, it hit the LPR camera like at 2 in the morning. So then shortly, the LPR camera is like a half a block from the parking deck. So we can assume that 201, 202, or shortly thereafter, the car went into, there's no timestamp on the video for the parking deck. But it was that evening, yes.
Okay, going back to my original question. The vehicle was not immediately stopped right after the incident, correct?
No.
So if there were other people inside the vehicle, then they would have long had plenty of time to leave the vehicle, right?
Yes, there was enough time between the shooting and the parking deck, yes.
Okay.
He wasn't driving Uber, was he? I don't think he had anybody with him.
I didn't get that, but that's okay. Did that end your investigation? Did that end your investigation?
What, finding the car?
Yeah, once you found the car and once you determined that, in your mind, one suspect, that concluded your investigation?
If I had any information that there was somebody else involved in this crime, I would have doggedly pursued that. I did not have that information. I have no evidence of that. No,
Okay. So you've never explored a second person?
no sir. No reason to.
Okay. That's all I have.
Redirect.
Yes, Judge. Sarge, on cross, you were about to give an explanation about sort of going frame by frame, and it's in the defense of caught you up. Can you please explain your answer?
Sure. So we try to pay attention to the details. Sometimes the details are what get us something. In this particular case, the video was really the best evidence we had, or I have. It's my job to make sure we're going to get to the truth as much as we can, and the video doesn't lie. So, based on my experience, I've seen a lot of videos. This is an excellent video. I've also watched videos of people committing crimes, people breaking into cars. I've watched people commit murders. I've seen a lot, and there's some certain things that It doesn't always happen, but it's a common denominator. It happens.
Judge, I'm going to object this time. What's the question? You sound like he's getting the commentary.
What was,
Restate your question.
Yes, sir. On cross, you were asked, how were you certain that you saw what you saw and what you saw related to the conclusions that you did? And you explained that you were looking at the video frame by frame, forwards and backwards in slow motion.
That's right.
Can you explain how all of those actions help confirm your investigation?
So when I pointed out to you about the camera being mounted to the truck and when he was in the truck's moving, we're all familiar with the cars. So my attention now is on the Kia. So I'm looking at the Kia and I'm looking at frame by frame and I'm looking at slow motion back and forth, trying to determine if there's anybody else in that car. If there's, from my experience, if there's another person in the car, in the passenger seat, they're not going to be ignorant to what King's doing. They're going to know. They're going to watch him just break the window and jump in. They know he's doing something. So even if they were ignorant, they're knowing he's doing something wrong, or they are familiar and in with him, and their job is to look out for him. So if they're going to do that, they're going to be in the car. They're going to be moving around, looking, and in that movement, the Kia will move. It'll jiggle a little bit while they're in there. Even if the windows are tinted, no lights on, it's going to indicate somebody's in there. They're not going to sit there. I have never seen somebody that has that job sit there like a statue while they're always looking around. So, it's my opinion, from my experience as a detective for 20 years, police officer for almost 40 years, there was nobody in that car based on that, just the human behavior. If somebody's doing something illegal and you're involved in that, you're going to be nervous, you're going to be looking around. Nobody's in that car with him. That car is rock steady. The whole time the King is out, and then the truck's moving. The car moves when King gets in and out of the car. But when the car is empty, the car is empty. There's nobody in it.
Thank you. Nothing further, Judge.
You wasn't there, sir, were you?
No.
The windows were tinted, weren't you?
Yes.
You wasn't there to see if anybody was in the car, were you?
No.
But the victim was there, wasn't
Yes.
he? And he said it was two black dudes, right?
With all due respect to Mr. Albee
My
and his
question
family.
is, did he
Just
say?
a minute, he gets to answer the question.
With all due respect to Mr. Albee and his family, I believe he was mistaken, considering the situation, the circumstances, and what he was going through. It happened very quickly, and you can see on the video, it's less than 2 seconds. It is dark, the windows are tinted, and the angle that Mr. Albee was in, and the quickness of the way it happened, I believe he was mistaken. Yes, sir.
So you have determined that the victim was mistaken.
That's my belief. Yes, sir.
Okay. And you wasn't there.
No, sir.
Nor did you see.
You're going to ask and answer.
Judge, no problem. I'm the type to thorough sifting process.
He's answered that question.
All right. You couldn't see who was inside the car, right?
I can see the outside of the car from the video. Based on my experience, like I explained, I can't say for sure, no, sir. I cannot say exactly for sure there's nobody else in the car.
Thank you. No further questions.
Nothing further from the State Judge for this witness.
Will the state have any other witnesses?
Judge, we just have evidence to attend to the record. Is the stipulation by the parties,
Please proceed.
which is marked for the evidence that states 137. And the parties stipulated on February 6th of 2026 that at the time of the indicted crime, Randy King was on probation as a felony first offender in indictment 19R00392 out of the Superior Court of Coweta County, Georgia, wherein he was sentenced to a 10-month probation on January 27th of 2020.
Does the defendant so stipulate?
Yes, Judge.
The jury can treat that as evidence. Will the state have any other witnesses?
No, Judge, I believe that the state would rest.
Ladies and gentlemen, you all get to go to lunch now. And we will reconvene. 1:15, okay, counsel?
Yes, Judge.
1:15, ladies and gentlemen. See you then.
All right, the jury.
testify in this case, that's up to you. Do you understand that? Do you understand that? I need you to answer out loud. Have you talked with Mr. Rowe about testifying? Okay, I'll just ask you a different question. Have you talked to Mr. Rowe about testifying? Okay, I'm just presuming you talked to your lawyer sometime.
Yes, sir.
And is it your decision to not testify?
Yes, sir.
Thank you. That will conclude the evidence. And so what we'll do, counsel, I'm going to add a little bit of language to the charge on the stipulation of the prior disposition order from Coweta County.
Yes, Judge.
I've got to add that. I've given pretty much all of the instructions requested by the defense. I think I've covered everything requested by the state, including party to a crime and so on. We'll talk. I'm just telling you an overview at this point. We're not making any decisions right now. And Mr. Rowe, I expressly have looked at whether or not to charge grave suspicion. You asked for bare suspicion. The actual charge is grave suspicion. And I've given that charge many times on the facts of this case and under the opinion of the Supreme Court in Adkins versus the state, reported at 314 Georgia 477. It's a 2022 decision that basically notes that giving the charge on bare suspicion or grave suspicion is something we should look at. On the facts and evidence of this case, I decline to give grave suspicion. So that's my ruling on that charge. So, and as I said, the case is 314, 477. There's other cases that hold the same thing. So I will, and I have included mere presence. And the other defense charge. And like I said, I've just included it. We'll talk more about it after you all get some lunch. 1:15, counsel.
Yes, sir.
Is that when the charge conference at 1:15?
All right, let's take up the jury charge. Any comments from the state?
Yes, Your Honor. Based on the current draft, Judge, on page 3, impeachment.
All right, that's just the beginning draft. Impeachment now reads, and I've been working on it over lunch, and I'll send you all another copy in a few minutes. We've not had any prior convictions. We've not had any prior inconsistent statements. We've not had any proof of general bad character. So under impeachment, the only thing that's left is just disproving the facts to which the witness testified.
I believe that's the only language that remains of this case, Your Honor.
Any comments from the defense?
I agree with the court, yeah.
Thank you. All right, so, and basically that paragraph 7 now reads 2 sentences. To impeach a witness is to prove the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. Next.
Next, Your Honor, going toward to page 6, or my page 6, possession of a firearm by first offender probationer. I believe the language should read, for possession of a firearm by a first offender probationer, as alleged in count 7, the state must prove that the defendant possessed a firearm while on probation for a felony as a first offender. That's just pulling the language from the pattern charge.
Does your stipulation show that it's, your exhibit, does it show that it's a felony?
The stipulation includes that language.
Okay. All right, let me read out what I've got. I made changes to that as well. For possession of a firearm by first offender probationer as alleged in count 7, the state must prove that the defendant possessed a firearm after having been placed on first offender probation supervision for a felony. The defendant has stipulated that as a matter of fact he was a first offender probationer, I'm going to say felony probationer, at the time in issue.
Yes, Judge.
All right.
That's fine.
Thank you. And that's treated as a stipulation. Next.
Judge, the state is going to object to any lesser offense given.
Just a second. Is there any request for any lesser included?
Judge, under the state's theory of the case, we think there's slight evidence of manslaughter, just based on the state's argument and the state's theory of the case.
Thank you. I disagree. I don't find any evidence of manslaughter, and I have taken out the language relating to lesser included because there was no provocation, no serious violent provocation at all. Rather, the evidence was that someone observed the defendant committing a felony and was shot.
Thank you, Judge. Your Honor, the only other comments the state has is for additional charges to be given. I did file a supplemental request to charge to include the pattern charge on conspiracy 2.02.20. I believe that language tracks along with the party to a crime. They kind of are in concert with one another. I did file that this morning for that additional pattern charge to be given in this case.
All right, conspiracy, and which was your paragraph number? Jury charge number.
It's 2.02.20. That's the pattern.
Let me look back at that.
And I will have an objection to that since there's a party to a crime pattern charge on that. I don't see any evidence of conspiracy even presented in this case, Judge. I definitely understand the party to a crime pattern charge, but to add a conspiracy on top of that, I would object to that, Judge.
Let me see, your paragraph you wanted is .20. That's basically the definition of conspiracy.
Yes, Judge, and as the pattern notes, there's some citation to some case law that conspiracy doesn't have to be a charge in the indictment for this pattern to be given, this pattern charge to be given. And I do think it runs parallel to the party to a crime language in law, that if the jurors do believe there was somebody with Mr. King, this conspiracy charge would instruct them on how to treat that.
I'm going to I'm going to reread the charge. I've just read it. I'm going to read it again and think it over, and I'll give you a ruling. Was there anything else requested by the state?
Yes, Judge. We are requesting that the pattern charges on for limiting instruction charges be given with reference to Mr. King's first offender disposition being introduced into evidence.
Thank you. I think that's appropriate. Any objection to that?
I would join in that, Judge, that's fine.
All right, so let's go to that part of the charge. Basically, I'm going to just tell them you can consider that stipulation only in regard to count 7.
And count 3.
And thank you, count 3, because count 3 is felony murder based upon being a first offender. So I'll put in okay, you can only, the whole sentence, paragraph will be, the defendant is stipulated that as a matter of fact he was a first offender felony probationer at the time in issue. You can only consider that evidence in regard to count 3 and count 7 and for no other purpose.
Yes, Judge.
Okay. Anything else? Thank you for pointing out that need.
Has Your Honor added the defendant's choice not to testify to instruction?
I have.
Then that completes the state's.
All right. Okay, I'm rushing you. I'm looking forward to y'all's thunderous closing arguments. So, yeah, I have added that. That's new paragraph number 20. So I want to go back to my charge on felony murder. I gave the extended definition of proximate cause, which that's been a matter of debate by the Pattern Jury Charge Committee of the Superior Court judges, and it came out of a case where the defendant was charged with murder because the defendant had spilled some fentanyl-laced opiate of some kind, and a mentally challenged child ate the chemical and died. And so that person was charged with felony murder for having possession of fentanyl, and someone died as a result. I don't always give the proximate cause definition beyond that which is stated, and I'm going to read it back to you, in the standard charge on felony murder. Which basically says this: you may find the defendant guilty of felony murder if you believe that he caused the death of another person by committing the felony of aggravated assault with a deadly weapon, or by committing felony possession of a firearm by a, and I'm going to add a word here, by a first offender felony probationer regardless of whether he intended the death to occur. The charge goes on to say there must be some causal connection between the felony and the death. Felony murder is not established simply because the death occurred at the same time as or shortly after the felony was attempted or committed. The felony must have directly caused the death or played a substantial and necessary part in causing the death, regardless of when the death ultimately occurred. Now, I had added the extended definition of proximate cause just as a matter of caution. I just do not believe on the evidence of this case it's needed.
I agree, Judge. If the jurors have questions about that, we can certainly revisit it, but I don't believe it's needed in the initial.
And I've rarely ever given it, to be blunt. That's only come up in recent years. But what about it, counsel?
I agree, Judge, it may be a bit confusing.
Well, I mean, going back to law school, it was confusing for us then. And I've never been happy with the tort law, and it's basically the tort law charge on proximate cause. And so, like I say, I think it's just unnecessary in this case. You know, obviously, an aggravated assault with a deadly weapon where somebody dies, it's obvious that has a proximate cause relationship. Same is true for the felony possession. Okay, so I've eliminated that language. Now, Mr. Rowe, I did tell you about my position on the grave suspicion charge, but I want to give you an opportunity to object to my conclusion, if you'd like.
Well, Judge, honestly, I do want you to give it. I understand the court's reasoning for not giving it in the case law recited, but for the record, I am still requesting the bare suspicion or grave suspicion charge, pattern charge.
Thank you. And as I say, this is not the first time I've come across that issue, and I'll do my best to follow what the appellate courts tell me is the law. Anything else from the defense?
No, Judge, I think we covered everything when the state was presented.
All right, so let's just go back and summarize what the charge is going to look like, and you have your laptop. I'll email you all the text as it exists in just a few minutes. But let me just start. Really, the main place we need to start is paragraph 15 is the offenses charge definition. And what I've tried to do there is to link the jury to each count number. And I've given the standard instruction on malice, murder, and so on. Counsel, one of the challenges we always have to do is match the language as we define the offenses to the language as charged. Have you all reviewed my instructions with that in mind?
I have it.
Yes, Judge.
Are y'all satisfied that what I've prepared matches the indictment?
Yes, Judge.
Yes, Judge.
And we have parties to a crime, failure to prosecute the principal or other involved persons, guilt by mere presence, guilt by mere association. I now have paragraph 20, new paragraph 20, which is the defendant's choice to not testify, the standard language on that. Then we go to verdict, and the rest of it's the standard instructions. So that's what you got. I am going to email this to you all again. I'm going to give you some time to go over it, and I will need you to rest in the presence of the jurors, and then we'll move into closing argument. And I'm going to give y'all, is 10 minutes enough time for y'all to proofread my work?
Yes, sir.
I always have an error in there. You know, I always find it when I'm reading it to them. So it's amazing how hard I try to catch them all, but still there's something there. All right. Anything else, Mr. Hawkins? You stood up.
No.
one little note. I noticed on the indictment that one of the counts had September 6th. I think that was a typo. Obviously, this, from the evidence, everything we know of happened on September 3rd. I've included the alternate date. I don't know, obviously, we're well within any alleged statute of limitations anyway, so.
Thank you, Judge. I neglected to mention that, but we agree that language is appropriate.
All right, counsel, I'll click send. Let's see how long it takes to get to you. Did you get it, Mr. Rowe?
I got it.
Okay, that was pretty quick then. I've stopped sending the attachments, PDF attachments, because oftentimes the system will screen those and not let them be delivered. So, well, I have to send it in the small print of an email. All right, counsel, what I'm going to do, I'm going to presume, Mr. Hawkins, did you, Ms. Charles, did you get it? Did you
Let me check.
Okay. Ms. Charles, you didn't get my first message to everybody because my computer had used auto insert and left the T out of Fulton
Okay.
in your email address. So I worked to get it back in there just now. Of course, once you get in a typo like that, you virtually never can get rid of them.
That's fair.
I'm going to give you all 10 minutes to go over that, and then we'll have closing arguments.
Yes, Judge.
Thank you. $1:35. I'll be back in at 1:45.
will want to double check.
Did I do wrong? It's just, I said it's a little backwards because the defendant looks hopeful, like.
No matter what, he's going freaking. Even if he can hold himself straight.
All right, counsel, we ready to proceed to closing argument?
Did Your Honor make a decision on the conspiracy charge?
I'm not gonna get it.
Understood.
I just don't think it's in it. Okay, so, I'll need you to rest.
Okay.
Anything else?
No, Your Honor. Thank you.
Jurors, please. Have a seat in the courtroom. Mr. Rose.
Judge, Mr. Rex.
Ladies and gentlemen, what that means is the evidentiary part of this case is over. And now we move to the closing argument by the attorney. The state, under the laws of particularly in our cases, has the right to open and conclude. Ms. Charles, you may proceed. Or Mr. Hawkins, whoever.
Thank you.
They don't have to tell me who's going first.
Surprise.
On September 3rd, 2023, Randy King made a series of decisions. And he made those decisions with two things in mind. One, I'm going to take what isn't mine. And two, I'm going to get away with it. You see, every decision he made went to support one of those two things. The manner in which he pulled in front of Max's truck. He sat there a bit, scoping it out, looking around. He even reversed the Kia several feet to position himself right next to the window he wanted to target. Randy got out of that car, dressed in all black, with his hood up initially, and gloves on his hands. He had a tool in his possession so that he could quickly and efficiently bust that window. These are the series of decisions he's making with those two things in mind. I'm going to get into this truck, I'm going to take what isn't mine, and I'm not getting caught. Throughout his time in that truck, he's looking around. His head is on a swivel because he's trying to do multiple things at one time. Not only am I trying to take what isn't mine, I'm trying not to get caught. Looking around. At one point, he bolts the truck, goes back to his car, gets a light. He's not satisfied. There's got to be something here I want. This truck is too nice. There's got to be something here for me. And as he went back in that truck, and as Harrison pulled down, Harrison began to threaten Randy. Because now Harrison is threatening Randy's efforts to not get caught. You see, this shooting wasn't out of the blue. It didn't fall out of the sky. It was the culmination of Randy King's decisions that I'm going to take what isn't mine and I'm not getting caught. I got unfortunately for Randy, but fortunately for justice, Randy did not know about and did not take into consideration the cameras Max had in his truck. And those cameras tell that story. That footage tells that story. And so, we're going to break our argument down into two parts, myself and then 88 Charles. And I'm going to talk now a lot more about the law that we'll be given to in this case, the law that applies to this case. And after I have a moment or several minutes to do that, I'm going to sit down and 88 Charles will stand up. Or excuse me, I'll sit down and then Mr. Rowe will have an opportunity to address you. And if he does that and speaks with you, he'll sit down. And then 88 Charles will have the final presentation. And she's going to get a lot more into the evidence of this case than I am. She's going to dig into all the facts and the videos and the angles and those sorts of things. So let's talk about what the whole purpose of the jury trial system is. And that is to seek the truth. Your duty as a juror is to be a fair and impartial juror, honestly seeking that truth. Your job is not to seek doubt. So in other words, what really happened based on the evidence that you have in this case? You make that determination. And then you apply the law that you're given to the facts as you find them to be. That is your role. And you have a duty to follow the law that the judge gives you. You took an oath at the beginning of this trial that you would do so. And so you are bound by the instructions that the judge gives you. You have to follow the law that is given to you by the judge. So again, what is your role? What is not your role? And so your role is not to bring any personal baggage into the jury room. Your verdict is to be based on the evidence and the law, not based on a personal agenda, political views, issues you may have with the criminal justice system, whether you like the police, whether you don't like the police, whether you like the law, don't like the law. It's not an attempt to make a personal statement or to change the system. We have other forums for that. There are other forums where you can advocate for that, but this is not one of them. As a juror, you have to follow the law that the judge gives you. And you're not an advocate for either side. You're an advocate for the truth. So I like to use this illustration to kind of hammer home what you can and cannot consider when you deliberate on this case. You can't consider passion, public opinion, whether you like the police, dislike the police, sentiment, sentencing. You will be instructed that sentencing is not for your consideration. You're to give no thought to it. That is solely for the judge. Sympathy for Mr. King, sympathy for Harrison. Again, whether you disagree with the law, any penalty or punishment, those are things you cannot consider when rendering your verdict. What can you consider, or what ought you to consider? Of course, the elements of crime, the law, testimony of the witnesses, their credibility, any corroboration of that witness testimony, expert testimony. You heard from Dr. Hubert in this case, his expert opinion. Photos and videos. The cornerstone of this case are those videos from Max's truck. The defendant's actions, right? Not just at the minute that the second the shot goes off, but his actions beforehand, his actions throughout the entering auto, his actions immediately thereafter. And of course, common sense. You got to bring it with you. You cannot check common sense at the door. Don't do it. You can't. You bring your common sense with you every day when you make big decisions. You must do so again. Do not leave your common sense at the door. And that's all a verdict is you take that evidence, you add the law to it, and you come to a verdict. Now the judge will instruct you on the presumption of innocence. And it's important you understand, again, what it is and what it isn't. At the start of this trial, Mr. King was presumed innocent. That is our legal system in the United States. That's the way it should be. purpose of the trial is for the state to have an opportunity to prove to 12 citizens of Fulton County that he did commit these crimes with the evidence we admit. So that presumption of innocence doesn't exist throughout the entire trial. It only exists until it is overcome by evidence to convince you beyond a reasonable doubt that he's guilty. And exhibit after exhibit, video frame after video frame, Randy King's presumption of innocence was gone. And he is no longer innocent today after we presented our case. Now, I said we have to prove our case beyond a reasonable doubt. We have that burden. We welcome that burden. It's where it should be. It should be on us. And it never shifts. It never shifts to the defense. But again, it's important you understand what beyond a reasonable doubt means and what it does not mean. What is it? The judge told you at the beginning of the trial that it's the doubt of a fair-minded, impartial juror honestly seeking the truth. It's a doubt based on, there are those words again, I'm going to come back to them time and time again, common sense and reason. We do not have to prove our case to a mathematical certainty. We do not have to prove our case beyond all doubt. And it is certainly not you going and looking for it. That is not what a reasonable doubt means. I like to use this illustration along those lines. And what you see here are a number of puzzle pieces in this illustration that are affixed together. But you'll also notice there's a number that are missing. And if I were to ask each of you, what does this picture show? What is this puzzle of? Each and every one of you would know that's a $1 bill. You say, oh, it's a $1 bill. And I could say, well, but you're missing pieces. You can't see what this piece would be. You can't see what this piece would be. You don't know what that piece, how could you possibly know this is the completed picture would be a $1 bill? That's because you have your common sense and reason. You have your life experiences. You know it when you see it. Now, I could stand here and say, well, you weren't at the factory when this puzzle was made. You don't know if there was some glitch with the machine and that this is a piece for some Disney character. You weren't there, were you? You didn't see the puzzle be made. But that would be an example of you going and looking for doubt, coming up with excuses, refusing to follow your common sense and reason. Now, I imagine the defense is going to get up and talk about what you can't see, what you can't see, what you can't see. He's going to be focusing on what he believes to be missing pieces. But you have enough pieces in this case. You have enough evidence in this case to know what happened and to know who's responsible for Harrison's death. Because you have your common sense and reason. You can see this thing unfold. You can see it start. You can see it in progress. And you can see the culmination of Randy King's desperation to get away, to not get caught. The judge will instruct you on direct evidence. And direct evidence is just like somebody's senses, what they saw, what they heard, what they smelled. Testimony of a person who has actual knowledge of the fact. Right? You heard a number of witnesses testify, heard the shot. But you will also be instructed on circumstantial evidence. Facts and circumstances that prove or disprove another fact by inference. And a key example of circumstantial evidence in this case is that gunpowder that was on Harrison's clothes, right? Dr. Hebert stated, really, to make a complete picture, to have a complete idea of how far that Dr. Rivera wasn't there to see the shooting. He wasn't there to hear the shooting, but he was able to look at the aftermath and see evidence that tells him circumstantially that gun was close. And then you get to decide how to weigh direct and circumstantial evidence. You don't have to give more weight to one versus the other. You decide how to use it, how to weigh it. Another illustration I like to use is one that if recall you're summoned for jury duty, and you know that once you come in for jury duty, you're going to be sitting in a room with no windows all day long. And you're going to be sitting in a room that is on the first floor, like you have been this week. So we're not directly underneath the roof. You can't see what's going on outside. But if you're coming into court today, you were to see the weather report that says it's supposed to rain. And if you come outside and you look and you see there are clouds in the sky, you drive into court and you sit here all day long. If you were to go outside later today and you see the ground saturated, covered in water, you were to see people walking by shaking out umbrellas, what would you conclude had happened while you were in court? That it rained. You wouldn't think twice. Now, you didn't see it rain, you didn't hear it rain, you didn't even smell it rain, but you know it rained because you're using circumstantial evidence that it rained. You heard about the report earlier. You had seen the sky before you came into court, and then when you walk outside, the ground is soaked, people are shaking out umbrellas, and you know circumstantially, beyond a reasonable doubt, that it had rained. That's how circumstantial evidence works. It can be very powerful. And so when you listen to this case, and when you deliberate on this case, you cannot forget your common sense and reason. Now, somebody could come up to you on the street and say, I know you think it rained, but it really didn't. This fire truck came by and sprayed the courthouse. Or, I know you think it rained, but we just finished putting up a movie set. It really didn't rain. You wouldn't give that person the time of day. You wouldn't even consider that. That, again, is an example of somebody going and looking for doubt, looking for excuses, ignoring the truth that's right there in your face. So again, when you go back to deliberate, you have to take your common sense and reason with you. Because you use it every day. A lot of times you don't even realize you're using it. But you certainly use it in big decisions at work, big decisions with family, and this is another big decision that you have to bring it along with you. Credibility of the witnesses. That judge will instruct you that just means their manner of testifying, their interest or lack of interest in the outcome of the proceedings, knowing facts about which he or she testifies, probability or improbability of testimony, and personal credibility as you observe. Again, who you believe, who you do not believe, and you make those determinations. Venue. The judge will instruct you on venue. Now, you heard myself and ADA Charles ask a couple times, what county did this happen in? And that wasn't just to keep you here longer. That wasn't just to stall. We actually have to prove this case happened in Fulton County. And we do that by asking these officers who know this area, are we still in Fulton County? Because if this crime occurred in DeKalb County, y'all wouldn't be here, I wouldn't be here, Judge Emerson wouldn't be here, it would be in DeKalb County. So we have to prove that these events, the shooting event, this entering auto occurred in Fulton County, and we did that by asking these officers those questions. Criminal intent. It can be shown in many ways, right? We can't get inside somebody's head. We can't read minds. And so how do we know what somebody intends to do? Well, the same way, not just in the criminal context, but in everyday life, you look at their actions. Actions speak louder than words. You can know what somebody intends to do by watching them, observing them. You know, watching Randy bust the window, watching him dive into the car with gloves on, looking around at 1:36 in the morning, he doesn't have to tell the camera occurred when it is the natural and necessary consequence of this act, right? Pointing a pistol at somebody's torso or somebody's chest and pulling the trigger, you can infer, yeah, he wanted to hurt him pretty bad. Because that's what happens when you point a pistol at somebody's chest, close range, and pull the trigger. It hurts them very badly and often fatally. So criminal intent doesn't mean an intention to violate a specific statute. We don't have to prove to you that Randy was intending, well, I'm going to violate OCGA 16-5-1, subsection A, subsection C. I'll also violate 16-5-24. That's not how the law works. It just means an intention to commit the acts which are prescribed, prohibited by law. So let's get to these counts. And I know ADA Charles covered a little bit of this in her opening statement, but I want to go over it again with you. What is murder? Count 1. It's when a person causes the death of another person unlawfully and with malice aforethought. So I want to focus on these words, malice aforethought, because a lot of people have this idea that every state has first-degree murder, second-degree murder, third-degree murder. Because you watch SVU, Law and Order, you watch all these shows, and you're like, well, certainly Georgia has some kind of first-degree murder. We do not. There is no first-degree murder under Georgia law, okay? And so what that means is that malice aforethought is not the same thing as premeditation. Malice is the unlawful intention to kill without justification. And we don't have to prove ill will or hatred. We don't have to prove that Randy hated Harrison when he pulled the trigger. That's not what malice means. It just means an unlawful intention to kill. And it can be formed just like that. It can be formed in a moment. There's no requirement under Georgia law for premeditation. Okay? So forget that concept of premeditated murder. That's not a play under Georgia law. It can be formed in a moment. The second Randy bolts out of that truck into the driver's seat and realizes that getting away isn't going to be as easy as I thought it would. Now I got to pull out this pistol and really make sure I can get away. That's how quickly malice aforethought can be formed. Okay? Don't have to prove that he broke into that truck intending to ultimately kill somebody. It can be formed just like that. It's the deliberate intention to unlawfully take someone else's life. It also exists when there's not significant provocation and all the circumstances of the killing. Again, all the circumstances of the killing. Look at the entire context here. We're not just looking at a snippet in time. We're looking at the entire context showing abandon and malignant heart. And how do you know he had an abandoned and malignant heart? Because he was willing to resort to gun violence to get away with his property crime. Whatever I have to do to get away, I will do to ensure I don't get caught. If I got to pull out a pistol and shoot the guy that's trying to hold me here, trying to keep me accountable for what I've done, so be it. I'll do it. And he did do it. That's malice aforethought. That's an abandoned and malignant heart. So when you plug in the facts of this case to the law, when you add the two together, it fits right in. Randy, this shooting caused the death of another person. It caused Harrison's death. There's no justification for this shooting with malice aforethought. And he showed that. Even if it was very brief, that it formed before the shooting, he showed it certainly. When you consider that he shot Harrison while trying to get away from a entering on him. Don't forget the context. Again, premeditation is not required. Proof of motive is also not required. You can consider that evidence as well. And obviously the motive here for him shooting Harrison is to get away. I think that's pretty apparent. But nevertheless, we don't have to prove motive to prove murder. Let's talk about the felony murder counts. And there's a key difference between felony murder and malice murder under Georgia law. Okay? Felony murder is when a person causes the death of another human being by committing a felony. In this case, it's the felonies of aggravated assault with a deadly weapon and possessing a firearm as a first offender probationer. This is key. for felony murder. We do not have to show malice. So all of my discussion about malice aforethought, you can forget it for felony murder. Malice aforethought only applies to count 1. It is not an issue for the felony murder count. Malice is not a consideration for the felony murder counts, or it's not an element, I should say. In other words, we don't have to show an intent to kill. For felony murder, all we have to prove is an intent to commit the underlying felony. And in this case, at the time of that shooting, Randy was committing 2 underlying felonies at the time he shot Harrison. Aggravated assault with a deadly weapon and possessing a firearm as a first offender probation when he was not allowed to. The Georgia law didn't have a gun. So let's break down aggravated assault and the possession charge. Count 4, aggravated assault with a deadly weapon when a person assaults another person with a deadly weapon. It seems pretty straightforward. You see that word assault, but it has a definition under Georgia law. You can't rely on what your definition of assault is or what you read in the dictionary when you were growing up. Under Georgia law, which the judge will give you, an assault is when a person attempts to cause a violent injury to a person. Just the attempt, not even the completion of it, but just the attempt to cause somebody a violent injury is an assault. Pointing that gun, pulling that trigger, that is an attempt to cause somebody a violent injury. To prevent that person from holding you accountable, from holding you on scene after you were breaking into that truck. Randy, he attempted to cause a violent injury by shooting Harrison, and he indeed did cause a violent injury. But that's all assault is the attempt to cause a violent injury. And what makes it aggravated is that he's doing it with a deadly weapon, right? If Randy were just to punch Harrison, throw a punch, shove, push, that wouldn't be aggravated because there's no element of a firearm being used. But Randy didn't just attempt to cause an injury to Harrison, a violent injury, by punching him, shoving him. He did so with a deadly weapon. That's why it's aggravated assault. So this fits right in. Randy attempted to cause violent injury to Harrison by shooting him with a firearm, and a firearm under Georgia law is a deadly weapon. Possession of a firearm by a first offender probationer. Again, when a person, Randy, possessed that firearm, he's in possession of that gun. While on felony, first offender probation, and that was stipulated to, that was the last piece of evidence that you heard, is that the parties have stipulated to that Randy was on felony first offender probation at the time of this event. Okay? So number 3 for this kind of checklist is already checked off. And then when you take those underlying felonies and you throw them back into the equation of felony murder, that's how you get the guilty verdict for both felony murder counts against Randy. Caused this death to Harrison with gunfire. He did so by committing aggravated assault with a deadly weapon and possessing a gun as a first offender probation. Georgia law included him for possessing a gun. Reminder, again, intent in felony murder is not malice. We don't have to prove malice to prove felony murder. We don't have to show an intent to kill. Only have to show an intent to commit the specific felony that is laid out in each felony murder count. And you don't have a copy of the indictment to reference back to as you deliberate. So in other words, a felony plus the death of the victim equals felony murder. And the judge will also instruct you that aggravated assault with a deadly weapon and possessing a firearm as a first offender probationer are felonies. Count 6, possession of a firearm during the commission of a felony, is a separate weapons offense under Georgia law. And it just means that if you're committing a felony against somebody and you've got a handgun or you've got a firearm with you as you're doing so, you're guilty of this additional crime. And again, that just, it flows similar to the possession of firearm under probationer, and that Randy had a firearm on within his reach, arm's reach, while he's committing murder, felony murder, and aggravated assault with a weapon. Entering an automobile is, pretty straightforward. It seems as if the defense is kind of conceding this count in the opening statements, but again, Randy is inside Max's truck without permission. That's on video. He smashes the window, he's wearing gloves, he's rifling through the truck, comes back with the light. So circumstantially, he doesn't have to broadcast out loud. You can watch him, and you know what his intent is, that he's trying to take something of value. And is a bit frustrated that he can't find something he wants pretty quickly. So he's guilty of that additional crime of entering the automobile, entering Max's truck. But one or more of you may be like, what if Randy wasn't alone? What if? Under Georgia law, even if somebody else was in that front passenger seat, which 88 Charles will cover all the reasons why there wasn't, but even if Randy's still guilty of these crimes as a party to them, okay? This is what party to a crime says. Every party to a crime may be charged with and convicted of the commission of the crime. Every party to a crime may be charged with and convicted of commission of the crime. Now again, we're not conceding that there was somebody else in that car. The evidence doesn't, the totality of the evidence doesn't support that. Even if Randy is still guilty as a party to that shooting. What does it mean to be a party to a crime? Well, an important thing is that it applies to every single charge in the indictment. It applies to every single charge in the indictment. This is party to a crime theory. And you are a party to the crime only if you directly commit the crime, intentionally help in the commission of the crime, or advise, encourage, hire, counsel, or procure gets another person to commit the crime. Okay? Now, party to a crime usually plays out where you got, the easiest example, you got 4 guys that get in the car together. They decide they're going to go rob the bank. Right? You got a driver, you got a front seat passenger, you got a gun. You got one guy in the back that's going to stand on the curb as a lookout. And you got another guy that's going to take the bag so that the money can be tossed into the bag. And so under this hypothetical, if that car pulls up in front of the bank, the driver stays behind the wheel, the gunman goes inside, the lookout stands on the curb, and the guy with the bag also goes inside. And in the commission of that robbery, the commission of that violent offense, the gunman shoots and kills somebody. Guess who's guilty of murder? All 4 of them. Because you're all participating together to achieve this common goal. They're all guilty of murder under party to a crime. Because they all sign up. Assumption of the risk. You know going into it, it could go left. Clearly, because that's why you have a gunman, that's why you have a getaway driver, that's why you have a lookout. Because problems may arise during the robbery attempt. And if it does, and the only guy holding the gun makes a decision to shoot and kill somebody, not only is the gunman guilty of murder, but all the guys with him that are going in for this common sin. So look at it this way. If there was somebody in that car with Randy, that person wasn't just there by accident. That person would have been armed with a gun, and that person would have been alert to what was going on. That person ensure that they could break into that car, take what they want, and that they could get away with it. And it is foreseeable, even if he didn't have a gun, even if it was some mystery person in the car, which there's no good evidence for, Randy's still guilty as a party to it. So quite frankly, under Georgia law, it doesn't matter if Randy pulled the trigger or if a buddy with Randy did. Randy is still guilty of all of these counts, whether he pulled the trigger or whether his partner in crime did. The only reason Randy would have had somebody there with him, if he did, was to serve some role in this. That's why there was a gun involved in this. Now again, our argument is that Randy acted alone, that he brought the gun. There's no mistake, either way, that there was a gun ready for use in that car. Ready to use against anyone that tries to get in the way of the effort to break into the car, take what isn't mine, and get away. So quite frankly, you don't even need to get hung up on it. Because no matter which direction you look at it from, Randy is guilty of all of these crimes. Whether he pulled the trigger, or whether the person with him, common scheme and plan, did it. Randy's guilty either way. So, don't get hung up on it. That's what Georgia law says. Consider each count separately. Okay, the judge will instruct you that you're to give separate consideration to each count in the indictment. And what that means is you have to be unanimous on each specific count, right? You all have to agree, count one, either guilty or not guilty. But you do not have to be unanimous down the board. In other words, you don't have to say, well, we have to be guilty 1 through 7, or we have to be not guilty 1 through 7. You just have to be unanimous for each count. So consider each count separately. If you get stuck on a count, and you've been deliberating on it for a bit, and you get stuck, come back to it. There's no order in which you have to consider these counts. You can go out of order. So don't think, well, we got to start at count 1, and until we get a decision on count 1, we can't consider any of the other counts. That's not what it means to deliberate on this indictment. But please remember the standard. Please remember the standard of proof beyond a reasonable doubt. And it's not you going and looking for doubt. It's you applying the evidence to your common sense and seeing that Randy is guilty. No matter which way you look at this evidence, he is guilty. We're asking you to bring justice to Harrison's family, to send a message to Fulton County, to send a message to everyone that you're not going to tolerate this. You're not going to tolerate this behavior. Find Randy guilty of these crimes.
Defense closing.
There were 2 black dudes. That's what the picture said. I want to just go ahead and address this real quick. The state would have you believe that if a party is with another person who's committed a crime, that they are automatically guilty. This is the concept of party with a crime. I don't care if you I expect the court to try to regard being with somebody else who's committed an act of crime. It's called mere association. And under Georgia law, I expect the court to charge you that if by a jury is not authorized to find a person who is merely associated with other persons involved with the commission of a crime guilty of consent in, of concurrent, ladies and gentlemen, let's cut to the chase. There was a second person in the video. The person that was there was the victim. If we're going to start discounting the things the victim said, we can't pick and choose what to believe. If the victim is telling us what occurred in the moment that it happened, you can't just discount and pick and choose what the statement is. But remember now, as we cover the burdens, my client enters into this trial with a presumption of innocence. He's wrapped, dipped, and clothed in that presumption throughout the entire case. And he wears that until and unless the state is able to prove beyond a reasonable doubt each and every allegation in the indictment. And we submit to you the state has not met its burden. The burden never shifts to the defendant to prove his innocence. He's not required to prove anything. Let's look at the state's case. We're going to share with you why we say the state has not met its burden. First witness the state calls is Officer Brown. She is actually part of the crime scene unit, CSI, something they call it. And she comes on the scene and she collects evidence, never locates a gun, never locates any cartridge, projectiles, ammunition, and also she never gives what we call a gun residue test, never given to the defendant to determine, which she testified eloquently that it is a test to determine if someone has fired a gun. That test is obviously never given, so there's no evidence that he even had a gun. There's no evidence he ever fired a gun. So that's what that established. Next stage witness is Ms. Harrison, and she is from the record. She's actually the record custodian for the 911 call. So she came. Her testimony was important to both sides because she established that there was a 911 call, which is interesting because the 911 caller who called 911 is stating that that as witness. Nor did I don't think that witness was ever interviewed by anybody, which is kind of strange because he might be the person that called 911 is one of the first persons on the scene that would see the most. And it's interesting the state did not have that witness, nor did the detective interview that witness. And then the next witness would be Noah, the parking attendant, which gave some good testimony. One thing that we established with Noah is that he said that he saw the silver Kia with dark tinted windows that he could not see inside. So he could not determine how many people was inside the vehicle. Did not make no determination. No one of all the witnesses that was there, no one could see how many people was inside the vehicle. I'm sorry. There is one witness that was able to see inside the vehicle. You know what that witness was? That was the victim. The victim is able to see how many people inside the vehicle. Because when he approached the car, the door was open. And when he stepped into the open door, he was able to see how many people were inside the vehicle. And when he saw two black dudes inside the vehicle, when he laid on the ground, he said, "Two." what we see. Is there another missing video or something? He wasn't there. He wasn't. I don't care how much experience he had, he wasn't there. But the one person that looked inside the car said, shoot, shoot, shoot. Now watch this. Mr. Randy King, we saw him on the video climbing over the seat, climbing back over the seat, climbing in the window, climbing everywhere, and he's gonna have a gun on him? Who would do that? Who would climb all over the place with a gun on them? He didn't have a gun. We would have saw it. We would have fell out when he climbed over the seat. We would have fell out when he climbed. He was doing too much moving around. We would have fell on the ground. We didn't see a gun. It wasn't in his hand. You know why? Because he had a mechanism in his hand to break the window. Then he had a phone in his hand. So where are you going to put the gun? Here's the phone. Here's the mechanism to break the window. Where's the gun? Because he didn't have one. He didn't have one. And if he was, and the victim was shot at close range could have been the passenger or the driver, even the back seat passenger. All of that was close range. Then we heard from Ms. Crawford, Ms. Becker, Melissa. I think it's Becker called her Melissa, but her last name was Becker. Melissa Becker said from the apartment complex that Randy's girlfriend resided at, said that I saw a gentleman on the video using her key fob. She didn't say Randy. It's not the car. She didn't say Randy. She didn't identify, but she didn't. She didn't say the date. She saw him on the video. Didn't tell us the time. He didn't see the video to verify if that was Randy on the video. Not enough for us to come to any conclusion about that. Next is Officer Christopher, who was working an extra job at the neighboring business that was walking distance from the crime scene. He said when he arrived, he was focused on life-saving CPR skills, so he wasn't paying attention to exactly what the victim was saying when he was on the ground. He did not draw into any insight as to the identification of the suspect that the victim gave because he was focused on saving his life. So we understand that. But the officer, Officer Joseph Thurman, the one that engaged the victim at the time of this is the officer that secured the statements from the victim about the two facts. He said, that's what's on the video, that's exactly what he said. Here's the question that I want y'all to see. This happened in 2023. This statement was given on the day of the incident. The lead detective, Detective Hogan, wasn't told this until a couple of days before trial. What kind of investigation is that? You didn't tell me you don't even have the last words of the victim? You don't have the most accurate description of the assailant? No one can tell you who did this better than the victim, and nobody gave you those statements? That's where you start your investigation. You start with what the victim said. You start with the description given by the victim, and you go from there. You don't start in your own mind, your own theory. You start with what the victim said. You interview the other witnesses. But you always got to start with what the victim said, who the suspect was. And that's why you know he made a mistake, because he didn't get that. So now what he's doing, Detective Hogan is covering his tracks. And so when you cover your tracks, you justify, oh, it's only one for the suspect. Because if you admit that there are two suspects, that means you made a mistake, and you can't close your case yet. So of course you're gonna say, oh yeah, it's just, come on. Yeah, it's just one suspect. The victim was incorrect. The victim was incorrect. No, it was two. It was two. And Mr. King didn't do it. And there's no evidence to suggest he did. There is evidence that he broke the law. That's one thing. There's evidence that he committed injury and harm. That's one thing. But there's no evidence that he shot and killed his innocent victim. None. None. And then, to make things worse, Dr. Evier, which is the state's medical examiner, he's what we call an expert witness. He's testified 102 times as an expert. He's out of the 102 times, he's testified 100 times for the state. 100 times for the state. Not only that, but he issues a medical examiner report and makes a determination that the range, the shooting range to the victim is not determined. You can't tell whether it's close or far range. But he gets a visit 2 days before trial. And this happened in 2023. He gets a visit 2 days before trial from the prosecutor with a shirt of the victim to look at. He's shown the surveillance tape where we see the victim is shot close range. We see it. And then he comes to the conclusion, oh yeah, it's close range. Well, we know that. We just saw that on television. Why is that important? Goes to the credibility of the witness. Goes to the credibility of the witness. We expect the judge to charge him on credibility, charge him on the interest of the individuals that testify. And so, as we look at this case, we again say that the state has not met these burdens. And the final stage with Detective Hogan, again, going back to Detective Hogan, how firm he was. It's okay to be firm if you got solid evidence. Just saying, I know it was him, I know. There's no gun recovered from Mr. King. There's no gun registered tested, it may be private weapon. It's just one shell casing inside of a car that don't even belong to him. Not even the car registered to him. And the shell casing inside the car just goes to show that somebody inside the car shot the gun. It don't show that Mr. King shot the gun. The video shows that the victim was shot, but it doesn't indicate he shot Mr. King. And just King shot the victim. The state has to prove that Mr. King had a gun. They haven't even proved that he had a gun. The state has to prove that Mr. King fired a gun. Just proving he broke in the car is not sufficient. That's not enough. Especially combined with the evidence that was given by the victim that there were two. That's definitely not enough to death two people. The state has to prove beyond a reasonable doubt. And as we look at the indictment on count 1 of murder, Mr. King did not cause the death of this victim. He can't be convicted of murder. He can't be found guilty of murder. Felony murder. He was not committing the felony of aggravated assault with a deadly weapon. Nor was he committing the offense of possession of firearm by a first offender probation, because he never had a firearm. So he cannot be found guilty of count 2, nor count 3, nor can he be found guilty of aggravated assault with a deadly weapon. Nor can he be found guilty of possession of firearm under the condition of a felony. Again, a firearm was never recovered off of Mr. King. A firearm was never seen with the firearm in the vehicle. He didn't have the firearm. He didn't run too much. There's no physical evidence. There's no fingerprints. There's nothing to indicate that he did anything other than murder. And that's all we do. So we ask that with respect to those counts that you come back with a verdict that speaks justice, and it's justice for all parties. Justice for all. And that's a verdict.
Thank you, council. Ladies and gentlemen, you get your afternoon stretch break. At this time, it'll be 15 minutes. You may step out. Minutes, ladies and gentlemen.
Thank you, Judge. Got $40.
40. That's a lot.
Tariff.
I just want to check with them.
Or is it just
Huh?
is it your bag or just mine?
Jack, mine's in here.
Have a seat, ladies and gentlemen. Thank you. Ms. Charles, you may proceed to your closing remarks.
Ladies and gentlemen, quite frankly, I am offended. I am offended that we spent the better part of 30 minutes listening to this defense attorney misstate the evidence, misstate the law, and in some cases, actually talk to you about facts that are not evidence. Because what defense attorneys tried to get you to do in the last couple of days is to look the other way. To not believe your own eyes, not believe your own ears, and not to believe the evidence that should be given to you. And to sort of discount that direct evidence and circumstantial evidence on the law that includes one isn't weighted more than the other. And in the beginning, when I had my opening statements, I talked to you about circumstantial evidence and the reasonable inferences we make as a result of considering the direct evidence and where that will take us. And so we'll start from talking about some of the things we said, correcting the misstatements, and then we'll go into the actual evidence. The defense counsel wants you to believe that not many people were actually there that night, and therefore the state charged Mr. King because it was convenient. That is not true. Defense wants you to believe that Mr. King was falsely accused and was merely present, and therefore he is not guilty. That is not true. Defense counsel wants you to also believe that Mr. King wasn't working in concert with anyone else, if you believe he was, which we could argue. But let's just say you give some credibility to that proposition, that he was really present, and he was not that happened. Defense wants you to believe you didn't see a gun, and therefore Mr. King is not guilty. That is also not true on the law. Again, it's that misdirection and trying to muddy the waters so you will get distracted and manipulated. Because as A.A. Hawkins said in the beginning, Mr. King thought what happened under the cover of the night would not see the light of day. And so there's a hyperfixation on there were no witnesses. Well, you saw for yourself it was one of the gloves. There will be no prints to be found. We never found it out. As we go into the evidence, I'm going to point out to you some key pieces of the state's videos. Now, when you go back, I'll ask you to consider as far as the presence of that. There was some inference that perhaps there was other police officers, there was no cross-examination question, there were multiple police officers around, perhaps Harrison could have just called the police. Under the law, and factored as that was as turning the law on its head, because the law doesn't prohibit you from interrupting a crime as you speak, but the law prohibits you from using force to escape from the consequences of that crime, when there is no legal justification for using that force. And so he starts off with attacking some of the credibility of the witnesses. He talks about Dr. Ebert. Dr. Ebert doesn't work in the state. Dr. Ebert is a medical examiner in Fulton County. Dr. Ebert is a neutral arbiter in this case. As with every single witness the state presented to you, we meet with our witness and we talk to them, we review their statements, we review their testimony. And Dr. Ebert said, he suggested, hey, if I review the external clothing, because remember what he testified to, Harrison came to him from reading. It wasn't brought to him directly. Now we know he died of a gunshot wound. We know that there was no soot and on the skin. But was it possible for it to be on the external part of the skull. Dr. Irby has said, possibly. Now, notice Dr. Irby doesn't go as far as saying, for the mere fact that the gunshot residue exists, that he can tell you when he shot. He doesn't go that far. He simply says it impacts the range. And when you see it, you've seen it for yourself. The shooting was close range. Harrison Oldie standing right by the driver's side door near the driver's side seat. So necessarily it's close range. We're not here to argue this point. What we're here to argue is whether Randy King is responsible legally for Harrison Oldie's death. And I submit to you in the totality of the evidence, he is. Detective Hogan rushed to judgment. You heard his testimony. He followed the best available evidence. He talked about sometimes at the beginning of an investigation, there are conflicting information. Some things are told by multiple officers who relay information to each other. And if some information doesn't make its way to him at the time, the information that the defense is relying on is Harrison's words, 2 black dudes. But you see, defense is trying to skip a couple of steps, because what Harrison said, and you'll hear it for yourself, when he talks about the 2 black dudes, it wasn't isolation. Harrison sets that in context. And notice what Harrison never says when it comes to statements. I should read it further. The defense wants to believe the videos prove nothing. But you shouldn't believe your own eyes and consider what you heard. Whereas the video shows you exactly what happened and how it happened. Defense completely glossed over context. You see, he wants you to go chasing phantom suspects and those. He doesn't want you to consider that the law says when you participate in a crime, when you help during the crime, you are just as guilty as every other person in that composition. Now, our theory of the case from the top is Harrison Oldie was shot and killed by Randy King. But you'll find that there is some credibility to anything the defense counsel has presented to you. Under the laws of Georgia, Randy King is innocent. That doesn't change. Randy King, when we look at the evidence, was not merely present. Randy King was not merely associated. Randy King was actively participating in all of the events that led up to the death of Harrison Oldie. And so the state wants you to do is to look at that, look at the law and see it. The defense counsel misstates the evidence. Kayla Gowdy wasn't. Kayla Gowdy was another woman from Detective Maxwell. She spoke to Kayla also. You heard in the beginning, I said to you, some witnesses, sometimes we go out of order because some witnesses are unavailable. We have scheduled. But you heard Kayla's words on that 911 call. And you heard what she had to say. And you heard from Detective Maxwell and Detective Donovan that when they spoke to Noah Harper and the other valet attendant, they both said the same thing as she said in a 911 call. I did not see it. I heard it. That is it. The defense talks about the gunshot residue must be administered. How could it be administered to the defendant when he put out the hand to the police? You heard from both Detective Hogan and Detective Maxwell and Crime Scene Tech Hollis. Gunshot residue is time sensitive. If you wash your hands, you rub your hands, the passage of time, that will erode any further what does he look like? And he said 2 black Jews. Could Harrison have been mistaken? But what Harrison made clear in his own words was he was breaking into the truck. And we've seen the only person breaking into that truck was Randy King. Again, we talked about the close range and the fact that Fed said, well, maybe somebody in the back seat shot. Well, again, you saw the video with your eyes on the seat again, sure. There was nobody in the back seat. You should, because the door wasn't open. The only door open was the driver's side door. So unless I need a failed physics class, I can't fathom someone in the back seat shooting Harrison over in that trajectory, as we saw. And then you have to consider, well, why if it wasn't the passenger side? Well, for the passenger to shoot in the seconds that we're talking about, we also have a driver right here. Is he going to risk shooting his buddy in the head to get to Harrison? I submit to you that's an unreasonable conclusion. I submit to you that the more reasonable conclusion is to escape the consequences of his actions. Randy King pulled the trigger. And said, oh, we didn't see the videos from Fairmont. The listener Binford testified he used a key fob. We never saw that. I guess in fact it was asleep this morning because I showed played those videos. And we reviewed them with Detective Hogan. And we saw the car coming around that corner, high rate of speed, going up into the parking garage. And we saw Randy King wearing the same clothes that he was wearing inside of Max Smith's truck. Exit the car, walk up to the front door, use the key fob. So, from the defense's perspective, we have no evidence. Again, I submit to you that the defense is engaging in this direction and reckoning. And what you should orient yourself to as you go back and deliberate is what the objective evidence tells you. And then what reasonable inferences can you draw from the objective evidence. And so we start from the very beginning. When we look at Harrison only, we know a couple of things from Harrison. At 1:38 a.m., the responding officers arrive on scene. Harrison is on in his waistband of his carcass as he's laying there trying to stay alive. So we know one thing about that night. Harrison Ovi was unarmed. He presented no danger, no threat of bodily harm or serious death or any type of serious injury to Randy King. When he confronted him, he had nothing in his arms and car keys in his hand. There is no legal justification for Mr. King's actions. Because you see, what defense wants you to do is start in the middle. What the state is encouraging you to do is start at the beginning. When we start here, point 1, Randy King, as you heard from the stipulation, was not allowed to be near within arm's reach of a firearm. Start there. Randy King was unlawfully in Max Smith's truck with the intent to steal. That is a felony under Georgia law. And when you're acting unlawfully, there is no justification at step 1. And then we move to step 2. Harrison only reacted to the crime that he's seeing occurring in step 1. And the judge will instruct on the law when you set a chain of actions into motion and the consequences of your actions are foreseeable. When we look at conduct before, during, and after, the law holds you accountable for the foreseeable actions that you engage in, you set in motion. So what Randy King set in motion by entering Max Smith's truck, and as the Hawkins said, his head on a swivel, he understands that there is some risk that he's going to get caught. He understands that there is someone, not be Harrison Obi, but someone And so any actions that flow from here that are foreseeable are to be taxed to Randy King. Because when we come to the reaction of Harrison Obi by intercepting the crime in progress, Randy King, we can focus on he was not going to be caught on that scene. Now, by law enforcement, lawless counsel. And remember when we talked about malice? We talked about malice not being ill will or hatred. That malice is also the reckless indifference to human life. When you take your hand, take a handgun and you pull that trigger, whether it's 1 time or 5 times or 10 times, and you speed off and you leave that person dead or dying on that concrete, you are indifferent to whether they live or die. When you leave them on that sidewalk and you don't call 911, you do not seek help. You continue to make good your escape. That, ladies and gentlemen, under the law is called implied malice. Because there's no thought bubble in Randy King's head that the law asks you to do, where he has to expressly say, I am going to kill you. That is not required. The law asks you to consider all of the conduct and apply the conduct to the law. And when you apply Randy King's conduct, focus on escape with that reckless indifference to whether Harrison Obi lived or died, that is malice. And that goes directly to count 1 in the indictment, because Randy King here is simply not justified. Randy King has simply driven off. Whatever was done in his car, whatever Harrison Obi was doing, the car was running, the door was open, he got into the car very swiftly, he's very nimble. All he had to do was push the gas and take off. He did not have to shoot. And whoever else was in that car, if you believe that, again, also did not have to shoot. They had other means. They don't trap fires. They could leave. They chose something far more deadly. Mr. King talks about mere presence, ladies and gentlemen, that's the evidence. Randy King initiated this entire tragedy from the very beginning. As we see here, his head is on that swivel. He is looking. He is not calm. The defense wants to believe when he has someone in the car helping him out, someone in the car with him. But all his actions point to a solo act that night. He approached the car that didn't belong to him. He entered without permission with the intent to commit a theft. The law doesn't require you to take anything from you. It's what you intend to do. And when you see him rummaging around, digging, exiting the car, coming back with an additional light, because he's determined to find something that fits, something that he wants, something that he finds valuable. And as you deliberate all the videos we were able to do to you for you, I want to point out to you something. As he's in and out that car, I want you to look at your hood signs. And I want you to consider how weighted down they are. And I will show you the second video. That hoodie pocket isn't flat on his stomach. There's something in that pocket. And again, we see the gloves. There's a little bit of reading. Because he didn't intend to get caught. He did everything to make good his escape once he had satisfied himself of whatever it is he was looking for. And so the danger started with him. So you are not merely present when you're breaking into the truck. You are actively participating. Randy King, multiple vantage points. Look at the technical, it's still a video now, you frame by frame. It's a little dark, when you do that, and when you have to do that for you, if you need it, you see Randy King is the only person that has there is no evidence of anyone else in the car with Randy except for what Harrison said to the two black dudes. And the defense wanted to believe it because but we'll ask the question in the comparison to this thing, and I'll show you why possible. And we'll be willing to consider it. At all times, Mr. King is behind that wheel. He is the controlling force. He is what's driving all of this actions forward. He has positioned himself to escape. So he was not merely present. And to the extent that you do believe someone else pulled that trigger, he drove that person away. He is the getaway driver. He doesn't drive away and say, hey man, I am not with you on this. I am not. No. We don't hear a peep from Mr. King. He drives off. He doesn't call for help. He's more than aware that Harrison has been hit because Harrison yells out, ah! So he knows he was hit. He didn't care whether he lived or died. He didn't care whether he survived the injury or not. He only cared about escaping. He only cared about not getting caught.
Man, what happened? You break in the cuffs and then shot me. Man, what happened? You break in the cuffs and then shot me. Man, what happened? You break in the cuffs and then shot me. Man, what happened? You break in the cuffs.
He was breaking into the car and he shot me. He was breaking into the car and he shot me. He was breaking into the car and he shot me. That simple. It's that simple. Nothing I said, nothing Detective Hogan will say, nothing the defense counsel will speculate about. It's not ready to the call. And earlier, I was pointing out some of the consistencies with regards to Randy King. From the beginning, from the entrance into the auto, from the time we next see him using Kari Sweeney's people, and as you weigh the evidence, I submit to you my first set of slides. I want you to consider I submit to you it's reasonable to conclude the gun he had in his person as offered his testimony. When he jumped out, I was racing past the guns in his hand, jumped in the car, cars and pushed, started running, drive, boom, take off. So I have to and we know this is the same night. Shoes, same shoes. you are underneath. So you have to put some weight up to it. And as he said, he couldn't say specifically what the person was saying, but it would be consistent with being positioned slightly lower to the person. Front to back. So we know, as you saw, Harrison is facing his aggressor. No shift or stippling, we know that, because his clothes were in there. And we saw the clothes is here for you to revisit. What Dr. Agena said, it was inches. Inches. So to defense counsel's point, backseat driver could have done it, passenger could have done it. I submit that that is inconsistent with what the physical evidence actually tells us. And of course, we know no projectile was recovered because it was through the hang on the left. Now, everybody said in the beginning, could Harrison have been mistaken? In that car, I said, on the seats is clothing, black shoes. And when you look at all the photos, you can see additional shoes in there. You see black puffer jackets. In those 3 seconds while he's processing, could he have been mistaken? I will leave that for you to consider. But I will submit the evidence is clear on whether Harrison was mistaken about the number of people in that car. He was very clearly shot. And if you believe somebody was in this back seat wearing that puffer jacket at the time, or in the front seat wearing the puffer jacket at the time, or any other clothing, legally, that does not change Randy King's position in any way, shape, or form. He is still responsible as a part of the crime. Because when you drive away after someone has been assaulted with a deadly weapon, knowing that that person could die or suffer serious bodily injury, when you drive away knowing that an intentional shot was released in the direction of Harrison over the gun didn't go back to the they, whoever, if you believe defense theory, pulled that trigger, it was intentional. It was targeted at Harrison. It wasn't outside the window in the air to alert him to scare him off. It was at his torso, and as Dr. Evans said, it went through his heart. It went through his heart. I told you the copious amounts of love in prison and lost. And yet Randy King, knowing all this, drove away. Ladies and gentlemen, under the law, he has aided and abetted. And when you aid and abet, you no longer get to hide behind mere association or mere presence. You have actively assisted another to avoid responsibility. You are a party to the crime. And so we submit to you every single element in our indictment has been met. And as A.D. Hawkins explained, for felony murder, none of that is true. Simply the causal connection of the felonies that were underlying, which was the aggravated assault, the injury murder, and Harrison died as a result of enduring those felonies. It doesn't matter who it was.
I would need to object. She said Intern Otto was underlying felony murder, so I would need to object on record on that.
I'll refer to the jury to look closely at the indictment.
Okay.
It doesn't matter who is doing what. At the time of the incident, Mr. King was engaged We don't need to show motive, but we did in this case. As A.B. Hawkins eloquently said in the beginning, he was going to escape. Maybe they were going to escape. Either way, they were not getting caught on that scene. However they had to do it, they were willing to take a life or seriously injure a life to make good their escape. Ladies and gentlemen, all of the evidence in this case points to one and only one logical conclusion. Randy King, by virtue of all of the choices he made on that night, set in motion a chain of events that directly connected to Harrison Owen's death. And wanted to come to court and tell you, go look for a ghost, go look for a phantom. You didn't see inside my closet to see the actual bullet muzzle and hit his torso, so therefore I'm not guilty. That turns the law completely on its head, and that's what the Lord George says. And is not what the Lord George becomes. The law says he is responsible. I was going to ask you at the end to hold him responsible, because but for his actions, Harrison Owen would be alive today. He would not have died by gunshot injury on September 3rd of 2023, but for Randy King. The only reason Harrison exited that car he was about to valet was because of Randy King. The only reason Harrison Owen yelled out what he had was because of Randy King. And the only reason he laid on that concrete, dying, was because of Randy King. No one else. He set all emotion, and he was accountable on the law. And so just sort of big picture, how do we know it was Randy King? We have a series of identifications. His father identified him right away, which was a that's my boy. Of course, it was difficult for Randy King Sr. to do that in open court, and we acknowledge that, we give him some grace, he's a staff. But he also understood he was part of the investigation, and necessarily had to have him presented to me while he told Detective Hogan. Weeks later, his mother turns to me, but weeks later, Detective Delaney says, by that point, it's all over the news. And there's a lot of publicity. They know Fugitive Squad wants him, they're looking for him, they're staking him out. And so, they arrange an attorney, which is fine if that's allowed. And then, of course, his lawyer concedes of that. It's running in trouble. No issue of identification, element one in the indictment, done. We know we're dealing with Randy King. Surveillance videos. Defense speculates about this possible second shooter, but again, the judge will instruct you that speculation is not evidence. Hypotheticals is not evidence. The only evidence you must consider is what you heard, saw, and witnessed from this box. And what you take back with you in other ways. That is it. And so, as we talked about from the very beginning of what the law says, two people go together to commit a felony, whether one stays in the car, whether one goes in, whether one pulls the trigger, if you're acting together, you are both responsible if one of them uses deadly force to the other. We know that King initiated the felony, we know that he was the driver's seat, he control the escape vehicle, we know he didn't withdraw, he did nothing to say, I'm not part of this at the scene. He took off at a high rate of speed, he did not stop, he did not look back, he did not aim Harrison Oldie, he did not call 911. Everything he did was in self-interest to make good his escape, because he didn't know. He didn't contemplate Max Smith's truck on that video. I thought his videos, if I'm not thinking, it might have been a car case. Ladies and gentlemen, that is definition of aiding and abetting. That is the definition of acting definition of parties to the crime. And I submit to you, all of that applies from counts 1 through 7 to Randy King. Defense says no gun, no face, no case. That is a statement of the law. As it said, as wrong in law is wrong in fact. We have the face. We have a case. And like I said in my opening, you do not need to see the gun to know that it was used. You hear it. You see Harrison's reaction after he was shot. You know he wasn't stabbed. You know a gun was present. It talks about no casing, the gun found on scene. Again, the gun and the casing actually traveled with the shooter, which we submit to you as Randy King. Defense tries to scapegoat by using Harrison's word to do, but again, glossing over the first two statements Harrison said. I think I can read. He says very clearly, it's very little and child. You can't jump over that. You can't leapfrog over that to land on what suits your theory of the case. And that is what he wants you to do. And that is why this is the case for the defense is a series of red herrings in this direction. Defense is going to imply that this is a rush to judgment, that there was no credible information or evidence that tied the charges to Randy King. And I submit to you, ladies and gentlemen, every single piece of evidence points one direction, and that is in the direction of Randy King. You've seen the videos, you've listened to the witnesses, you've read the autopsy, the weight of the evidence, the totality of the evidence points to Harrison Bowlby's death needs to be taxed to Randy King. He is responsible for Harrison's death. Let's talk about why this matters. Ladies and gentlemen, on behalf of the state, Mayor Hawkins, I want to thank you for your time. Thank you for listening, taking good notes, paying attention, being on time. You've been with us for the ride for the last since Monday. This is important. There's a heavy decision we're asking you to make, and we don't ask you to take that lightly. Because the truth is relentless to those who fail to seek it. Harrison Bowlby deserves the truth. He deserves the truth. And the weight of the evidence points to that truth. And that truth is you are authorized to find Randy King guilty of what happened in the day. Because as I said earlier, he thought what happened in the dark would not see the light of the day. He didn't care that there were pictures driving around with about the day. September 1st, what? But then weekend folks are having a good time. He didn't care. There's officers working extra jobs all around the area. A lot of officers near the Limburg station. He didn't care about any of that. He was fixated on what he wanted was to take from someone else. And when Harrison Bowlby tried to stop him taking from someone else, he responded to him. And so we ask you to shine a light that speaks a true and just word, because this defendant does not get to murder some brother, friend, nephew, cousin. Not here for the count. In fact, not any count for the law in the United States. One shot is enough. One bullet is enough. You didn't have to unload the clip for you to find that story. One death is enough. One moment of escalation is enough. Because the law doesn't scale by the number of shots that leave that barrel of that gun. It is enough that Harrison Bowlby lost his life that night. So by your verdict, they're asking you to leave this body. Fine. And guilty on count 1, guilty on count 2, guilty on count 3.
Thank you, counsel. My plan is to give the jurors the law in the morning at 9 o'clock. Any objection to that?
No.
No, Your Honor.
They've listened a good bit today.
Yes. That's correct.
Ladies and gentlemen, please return tomorrow at 9 o'clock a.m. Please continue to keep an open mind and don't jump into conclusions about today. I will give you the instructions on the law tomorrow. Reiterate, keep an open mind, don't be any independent consultant, let anyone talk to you about the case. And
All right, adjourned.
Good night, counsel. Yeah, didn't have enough to print the charge, and I still need to print the verdict. Yeah, I need another ream of paper. 8 minutes by 11.